Minister was empowered to disband the task team, the manner in which he did could not be lawful and resulted in operational confusion. On the one hand, Lieutenant General Sibiya took certain steps to take transfer of the dockets while claiming to execute an order from the Minister, whereas on the other hand, he circumvented the National Commissioner who was at the time taking steps to prevent the disbandment.
And in fact, just to locate that evidence in its proper context, given what you said earlier, by this bypassing, you're referring to that incident of the 14th and the 15th of January, where the engagement between Lieutenant General Sibiya and the National Commissioner was concluded on the basis that the National Commissioner said to Lieutenant General Sibiya, leave it to me, I'll deal with it, and he did not sign the letter.
That is correct.
And then on the 17th, after a day after the minister was briefed, Lieutenant General Sibiya then decided to write that letter.
Or to sign the letter.
Well, sorry, yes, to sign it in his own name, despite having said to despite the National Commissioner having said to him he should leave the issue.
That is correct, Mr. Madal.
And you say that brings in sharply, or rather sharply into the question whether could the Lieutenant General Sibiya bypass the instructions of the National Commissioner on the justification that he was implementing the minister's directive?
No, the decision to sign that letter circumvented the clear instruction of a National Commissioner.
Before you go to the next section, just out of interest, General, when did Legal Services first become aware of the letter of 31 December 2024?
Commissioner, I can only speak for myself, and it wasn't in January. I heard rumors that a letter was leaked, but as a good lawyer, I don't pay any attention to rumors. I want to see hard evidence. So as far as I recall, I wasn't aware of that letter in January. For the rest of my colleagues, I cannot testify to their knowledge.
And as far as you know, was there ever an internal discussion about the lawfulness or otherwise of that instruction?
Not
I know
that
there
I
was
was
nothing formal because General Masemula said
Yes.
he did not obtain a legal opinion.
Not
But
that
just
I
out
was
of
part
interest,
of.
Are you aware if there was ever any internal discussion from
Not
the
that I
lawyers?
was part
Because-
of.
Yeah.
Yes, not that I was part of, Commissioner.
Thank you, Commissioner Kumalo. Then your next section is headed General Observations on Legal Aspects Raised. If I can ask you to then take it from paragraph 112 and following.
Chair, the purpose of this is, I've been here for a couple of days and I've also made notes on some aspects that were raised by yourself and by the commissioners on legal aspects. And I appreciate, and I believe you will also appreciate, that the two previous witnesses were not people with any legal background. And therefore, I believe it may be to the benefit of a commission to at least clarify some aspects in as far as I can to assist the commission. In furtherance of some of the issues raised by the commission, I wish to point out certain aspects to assist the commission. Firstly, the letter of the Minister, dated 31 December 2024, also directed that the filling of vacant posts in the Division Crime Intelligence, both at provincial and national level, should be halted immediately. No explanation was provided for that direction by the Minister.
Perhaps if I could just, for record purposes, that's VR1 in Van Rooyen 2 at page 102, paragraph 1.
That is correct.
Okay. Yes. Yes, if you can proceed.
Section 27 of the SAPS Act provides that the filling of any post in the service, whether by appointment, promotion or transfer, should be done in accordance with this Act which also includes the SAPS employment regulations. Section 28 furthermore provides that the National Commissioner may appoint a person to a post in the fixed establishment of a service. Regulation 27 of the SAPS employment regulations provides that the National Commissioner must inter alia, before filling any vacancy, confirm that he or she requires the post to meet the objectives of a service and ensure that sufficient budgetary funds are available for the filling of a post. The involvement of a minister in respect of a filling of posts are limited to senior management services members, that is, employees appointed to a post-level grade on 13, in other words, brigadier and above. Insofar as the National Commissioner is, in terms of Regulation 27, required to report to the Minister on this information and to obtain any directions that the Minister may issue. There is, however, no provision in the SAPS Act or employment regulations that authorizes the Minister to blanketly halt the filling of posts in a particular division of a service or even in the service as a whole. It is my considered view that the Minister's conduct constituted executive overreach.
Right. After that conclusion on that paragraph 1 of the Minister's letter, you proceed with your second point in paragraph 116. If I can ask you to proceed from there.
During the testimony of a National Commissioner, an issue was raised on the possibility of approaching court to resolve the impasse with the Minister. Assuming that this evidence is accepted, it should be noted that there is a principle that the state does not litigate against itself. In other words, the executive and head of department should not resolve differences or disputes in court. And the reason for this is the state attorney is responsible for litigation on behalf of the state. So the state attorney will act for both the executive and the head of department, which brings a conflict of interest. It is in part, this is also in part necessitated.
That can be a very serious stumbling block, because I've seen in such instances the state attorney using private attorneys or the client itself, whether it's a client department, going to private attorneys itself. So that's not really an impediment.
There's exceptions, but the exceptions are meant to be not the general rule or really exceptional circumstances that necessitates this, but this shouldn't be a matter that's considered lightly. Not in view of the seriousness of the dispute, but in view of the seriousness of the consequences of litigation.
Yeah, I'm just mentioning it
Yes.
because, for example, the example you give would be exceptional circumstances, I would have thought. Yeah.
General, isn't the issue this, that the Commissioner could have obtained legal advice, and if that advice said the instruction is unlawful, then he could have said to the Minister, Minister, we will not implement your instruction because it is unlawful.
That is correct, Commissioner. He could have sought legal advice, not going to court. But the issue I'm addressing is specifically, I remember there was a question on the possibility of litigation. But I agree with your approach. Legal advice should have been sought to get clarity on the legal position.
Yes, and perhaps if I could just come in there, the National Commissioner, when dealing with that issue, he gave his reasons why, for him, taking on his own minister was not an option. And I think the Commission will have regard to his evidence, because he did deal with that issue. And if I can ask you perhaps to deal with 117, where you start with Chapter 3 of the Constitution.
Chapter 3 of the Constitution.
Sorry, General, before
apologies, Commissioner.
Yeah, before you do that, and do pardon me for taking you back to paragraph 115, your conclusion that the minister could not blanketly halt the filling of posts. This is something that I guess one should have explored with the National Commissioner, but now that you speak to it, let me check this. We didn't get to see the advert for for these crime intelligence positions. So we don't know whether they were advertising for positions where the minister is required to be consulted. I think you said in consultation, and then there's a level where it's the National Commissioner's decision. Are you able to say what positions those were?
I have no knowledge of that, Commissioner. However, what is concerning is there's no differentiation or qualification of a filling of post. So I would assume that it cuts across different levels. It didn't even say only the filling of senior managers. So there should be posts available on different levels, including junior levels, medium managers, and senior levels.
And to your knowledge, do ministers or Minister of Police become interested in the advert? The evidence that we had was the minister picked up something about the advert, said it initially advertised for a diploma or a degree, and then he had views about it should be changed. Is that something that ministers become involved with?
Not in my experience, Commissioner. In fact, it's more of a pro forma advertisement that we have when posts, for example, becomes available or are to be filled in legal services. There's almost a pro forma requirement of certain requirements pertaining especially to qualifications. And you would expect, for example, a media manager to have a certain number of years experience and a certain qualification. So it is not something that the minister would get involved in or play any role in. On that regard, if I can also clarify, earlier this morning we discussed the issue of Regulation 47 of the employment regulations that specifically deals with the involvement of a minister in the appointment of senior selected SMS posts. And as I indicated, it relates to generals posts, in other words, major generals and lieutenant generals, excluding provincial commissioners, but including divisional commissioners and deputy national commissioners. And the difficulty with that is that the selection panel and the actual appointment must be done in consultation with the minister. So that also is problematic because it means that the minister's agreement in the appointment of any general, excluding provincial commissioners, are sought. And that is also a matter for consideration, the implications of that.
Thank you, Commissioner Butler. Earlier on, I referred to the National Commissioner's evidence regarding Lieutenant General Sibia's 3 areas of contentions. If you recall, I touched on that issue where there was an expression of certain of the dockets in crime intelligence being moved into his portfolio, you remember? Then I also said a National Commissioner testified that even when the minister took office, he expressed the 3 identical points that General Sibia had identified earlier, you recall? And I had left this issue, didn't deal with it, as the second issue that relates to crime intelligence, where the minister directs a halt. But I think let's leave that, and perhaps the minister will explain
Yes.
his interest in crime intelligence. If I can then ask you to proceed to 116. Secondly, sorry, is that where we were? Sorry, no, sorry, I apologize.
Yes.
We had dealt with 116. You were going to 117, chapter 3. Yes.
Mr. Madau, I was in part busy with 116.
Okay.
And the point I still want to make there is pertaining to the issue of litigation between the executive authority and the head of department, and also to indicate that another factor to consideration in an attempt to avoid litigation is that this is in part necessitated by the fact that public funds will be utilized to litigate, and an accounting officer is required in accordance with Section 39 of the PFMA to ensure that expenditure of his department is in accordance with the vote of the department and the main divisions within the vote, and that effective and appropriate steps are to be taken to prevent unauthorized expenditure. And you can never budget for litigation. In the police, we are well aware of that, especially in view of a contingency liability of civil claims. So it's not something that you can budget for.
Okay. All right, I think your point is taken. Paragraph 117, Chapter 3 of the Constitution.
Chapter 3 of the Constitution furthermore emphasizes the need for cooperative government and the need for all spheres of government and organs of state to cooperate. Surely these principles can also be expected to be complied with within a department itself, and not only to regulate relationships that exist with other departments or other spheres of government. This matter is even more critical within the security cluster, where sensitive matters are discussed and shared, and where the potential disclosure of intricacies of disputes may negatively affect safety and security of a country. Thirdly, the terms of reference of a commission provides for the consideration of the effectiveness or failure of oversight mechanisms. In my view, the commission, and not the committee,
Should be the Commission.
should consider this aspect continuously in the evaluation of evidence presented. However, in my view, the question should also be posed whether oversight could or would have made a difference in some of the matters. For example, the Commission has been presented evidence about the conduct of Lieutenant General Sibiya relating to a letter presented to the National Commissioner to formalize the disbandment of a task team. Assuming this evidence is accepted, the conduct of Lieutenant General Sibiya to repeatedly approach the National Commissioner with the same letter on subsequent dates and thereafter signing the letter without authority, while he was fully aware of the instructions of a National Commissioner, is not a matter that could be dealt with by means of oversight or more effective oversight.
Please remind me of the repeatedly. I thought General Sibiya met the National Commissioner. The National Commissioner said, I will attend to the matter, forget about your letter, and then General Sibiya signed the letter himself. Just remind me of the repeatedly.
It was 2 consecutive days, Chairperson. I believe is it 14 and 15?
My co-commissioner, Commissioner Kumalo, has a better memory than I am, but of course I'm sure age accounts for that.
Commissioner Kumalo, I appreciate your assistance.
Yes, yes, it was 14 and 15. You're quite correct. Thank you, Chair. Yes, and you say according to you, you were dealing with that issue. It is not a matter that could be dealt with by means of oversight or more effective oversight. Perhaps you can finish that part and then.
Let me just find it.
Yes. According to
the testimony of a National Commissioner, his instructions were ignored by a Deputy National Commissioner.
I think he also says that in the affidavit,
yes,
in the High Court application.
Yes, and I think in this regard it may be important to note that oversight is really outside the organization. In this case, the issue related to internal disregard of instructions, and especially in view of a chain of command in an organization such as the police, and the compliance of an instruction is critical to ensure that policing operations and command structures are respected. So I cannot disregard an instruction of my commander. It simply doesn't work that way in the police for good reason. And I realize, Chairperson, there's going to be exceptions, but I believe you will understand and appreciate the point as a general rule that I am making.
So can I just ask you, just to clarify that point a bit, you say oversight is external. In other words, it is looking outward, as opposed to oversight that looks at the internal mechanisms.
There are internal mechanisms, for example, the discipline regulations, and that will be the appropriate manner to deal with subordination. But I think the focus has been so far, especially in the discussion on the oversight bodies, for example, the portfolio committee on police, even the other departments within the ministry, their involvement in this matter this matter falls outside that issue of an instruction of a junior, in this case the Deputy National Commissioner, disregarding the instruction of his commander. And in that regard, oversight and the possibility of strengthening oversight should be carefully considered in view of the fact that it's not a normal process. And for example, by extending additional powers to a Chapter 9 institution, you cannot prevent this occurrence, or it couldn't have been foreseen to prevent such an incident.
So in other words, this issue that the Commission is dealing with here at the level of facts, and assuming that evidence is accepted, it is not an indication of lack of oversight or even legislative inadequacies. Because you say in terms of the chain of command and the ordinary rules of employment, it was not to be expected that after the National Commissioner had instructed the Deputy National Commissioner to leave the issue with him, that the Deputy National Commissioner would go ahead and issue that letter in his own name, which we know from the evidence that the National Commissioner gave that he only found out about that letter much later. And that's the point you're making. It's not an oversight issue or lack of oversight or legislative inadequacies, but it is, as you say, something that happened internally that could not have been anticipated.
That is correct, Mr. Madau, yes.
So I forgot to say, when I ask a question, you always respond to the chair. So the question, although it comes from me, the answer is always to the chair.
I hope this is the last time I need to apologize for today.
No, sorry, it's my fault. I didn't clear that with you. In fact, that point about the National Commissioner only becoming aware of the existence of the letter signed by the Deputy National Commissioner much later, you say it cannot be overlooked. This is in paragraph 120. It points to the disregarding of an instruction of a commander, in this case, the National Commissioner.
That is correct.
Okay. If you can then proceed from 121.
In addition, the National Commissioner testified that he had doubts, though he did not express them, on the lawfulness of the instruction of a minister on the disbandment of or the establishment of a PKTT, but elected to facilitate and oversee the winding down thereof on his terms, for reasons explained in his testimony. The nature of an organization such as the police requires a clear chain of command and requires respect for instructions and directives. The National Commissioner had no reason to doubt the bona fides of a minister at the time of the direction or directive, or to second-guess the motives of a minister. The apparent motives for the directive only became evident later. The reasonableness of the conduct of a National Commissioner in this regard ought to be considered within the context of the circumstances at the time, and as he indicated, he was surprised by the directive and the lack of explanation for the decision. However, the difficulties that flowed from the Minister's directive cannot be attributed to a lack or failure of oversight mechanisms, it is attributable to factors that came to light much later and on account of discoveries from the ongoing investigation testified to by the National Commissioner. These discoveries point to both the Minister's and General Sibiya's conduct. In this regard, the National Commissioner testified at paragraph 182.2.
So 184?
184.2, subsequent phone records obtained from an attempted murder accused revealed communications implicating Lieutenant General Sibiya in the forceful and immediate implementation of the Minister's directive to disband the PKTT. These records suggested that Sibiya's actions were not merely procedural, but rather tied to deeper connections with individuals identified as members of a criminal cartel. The timing and urgency of his compliance appeared to align with imperatives to shield cartel members from ongoing investigations. This is the subject of an ongoing criminal investigation. Then the National Commissioner also at paragraph 188 stated, in respect of the Minister knowing what I know now, what I've considered to be irrational and inexplicable encroachment upon operational issues is now explained by his desire to hold investigations against criminal cartels by disbanding the PKTT. By this I mean the evidence that has emerged with links the Minister to Brown Mkhotsi, Kat Matlala and Lieutenant General Sibiya.
And if I can just pause there and qualify it the same way that you did when you refer to evidence that has been placed before this commission. It is obviously early days at the commission, and the commission will still hear more evidence. And this is all predicated on this evidence being accepted. And you say, if after hearing evidence of the Minister and Lieutenant General Sibiya and all other relevant witnesses, and this evidence is found to be undisputed or to be accepted by the commission, the point you are making is both the conduct of Lieutenant General Sibiya and that of the Minister, and again I qualify it, if so found, does not point to and or is not attributable to the lack of oversight mechanisms or the shortcomings in the legislative scheme that you touched on earlier. In essence, that's the point that you are making. Am I correct?
That is correct, Commissioner. Chair.
Yes.
That is correct.
And this does not detract from the other legislative amendments, or at least the reforms. Perhaps let me just take one step back. This does not detract from the later point that you make, where you identify certain legislative gaps or certain oversight mechanisms which you deal with on a preliminary basis. And you make it clear in your affidavit that SAPS intends at a later stage to make comprehensive submissions to the Commission for its considerations when it makes recommendations in respect of the proposed methods by which oversight mechanisms can be strengthened and the various legislation that you've identified. Am I correct?
That is correct, Chair.
Okay. Then proceeding in paragraph 123, may I ask you to take it from there? Finally,
I wish to provide some clarification in respect of the role of a Chief of Staff within a ministry. This role is regulated by Chapter 3 of a Guide for Members of the Executive, also referred to as the Ministerial Handbook, which deals with the appointment of certain staff in the office of a minister, including the appointment of a Chief of Staff, a Private Secretary, and a Media Liaison Officer as part of the office of the Minister of Police. The Ministerial Handbook, Chair, I thought I was done with apologizing, but I am apologizing again. The words that a Chief of Staff in that paragraph should be deleted. The Ministerial Handbook provides administrative and support assistance to the Minister in ensuring good governance with due regard to cost effectiveness and efficiency. In other words, that's one of the aspects and aims of a ministerial handbook, to provide clarity on the administrative support and assistance that a minister is entitled to. And it should also be noted that appointments of personnel in the office of the minister, in this case the Minister of Police, are regulated in terms of the Public Service Act. The duties of the Chief of Staff include to ensure that administrative support is rendered to the Minister in respect of parliamentary services, including to coordinate parliamentary questions, to perform administrative functions within the office of a minister, such as internal and external role players with regard to the portfolio of a minister, and to manage the office of a minister effectively. This relates to the management of human resources and the budget of the office. In other words, these are the general powers or responsibilities to be performed by a Chief of Staff. The Chief of Staff may participate in discussions with the Minister and the management of the police. And in my experience, it really depends from minister to minister. In some cases, the Minister is, or the Chief of Staff is more involved in discussions and with the Minister and management, and in respect of other ministers, the Chief of Staff will be more in the background dealing with administrative matters. However, it should be noted that the Chief of Staff does not have any powers relating to the execution of policing functions. In terms of Section 207, the National Commissioner is responsible to manage and control the SAPs and remains accountable for the decisions taken by the SAPs.
And I think in this regard, the National Commissioner, when asked regarding the participation of the Chief of Staff in respect of decision-making, in respect of that plan, he indicated that when it comes to accountability, he, the National Commissioner, is ultimately accountable. And this makes it clear, I think, if one looks at the 2 points that you make. The first being that the Chief of Staff is appointed, or the appointment of the Chief of Staff is regulated by the Public Service Act, which you make at the end of paragraph 123. And then in respect of 125, you say the Chief of Staff does not have powers relating to the execution of policing functions. So those 2 read together makes that point explicitly clear. Do you agree?
That is correct, Chair.
Can I
And then
just
in terms of
can I just to clarify, General, you had the evidence of General Masemula that the Chief of Staff was advocating together with General Sibia for the immediate disbandment of the PKTT. Now, you accept from your evidence, you accept that, or at least you tell us that, Chief of Staff can participate or do participate in discussion between management and the minister. Does that go as far as this kind of evidence where General Masemula says he was advocating for the immediate disbandment? Does the involvement of the Chief of Staff contemplate that kind of involvement?
Commissioner, in my experience, the Chief of Staff will be part of a meeting. He may say something, but I haven't had experience where such a strong opinion has been expressed in respect of any policing matter relating or coming from the Chief of Staff. That is not in my experience the position.
Thank you, Commissioner. Then you were done, you just concluded with 125, and you're dealing now in the next section with the deficiencies that you've identified. And I again just remind the commissioners that you had indicated that for now, as you stipulate in 126, you make these observations on a preliminary basis, so that the commissioners can take them into account as they hear testimony from different witnesses, and perhaps they may wish to test some of these issues with whichever relevant witnesses that would still come to give evidence. But as indicated earlier, a more comprehensive submission is going to be made by SAPS at a later stage. Is that correct?
That is correct, Chair.
Okay. Then in your endeavor to assist, you say in paragraph 127, you seek to highlight certain deficiencies in the statutory scheme and flaws in implementing the oversight mechanisms. And you start with the civilian secretariat. If I can ask you to comment from paragraph 1 to 8.
In terms of section 6.1 of a Civilian Secretariat for the Police Service Act, the Civilian Secretariat is mandated to monitor and evaluate the performance of the police by regularly assessing whether SAPS have adequate policies and effective systems in place, and furthermore to recommend corrective measures where necessary. The Civilian Secretariat is further required to advise and support the Minister of Police in the exercise of his or her statutory powers and functions, and to report to the Minister on SAPS's performance, as well as its implementation of and compliance with policy directives or instructions issued by the Minister. By constitutional design, the Civilian Secretariat functions under the direction of a Minister, and that is set out in section 208. The current legal framework does not permit the Civilian Secretariat to operate independently, even though it is expected to maintain an independent character in exercising oversight. Its effectiveness, therefore, rides on the Minister's strength, credibility, and willingness to respect the policy or operational divide. Its authority depends on political rather than statute-backed autonomy. Oversight facilitates with cabinet reshuffles. Sorry?
So oversight vacillates?
Vacillates, with cabinet reshuffles and ministerial preferences. And if I can make a very basic example, the Minister of Police is responsible for the police and the same minister to oversee the police. Now, if the two departments are at loggerhead, it means the minister must decide which of his children is correct. And that is a very dangerous position. There should rather be independence to ensure that it is a more neutral or objective decision to be taken.
So the essence there of the point that you are making is, on a forward-looking basis, some form of disentanglement that allows for independence is something that you say ought to be considered by the Commission as it navigates the issues and hears evidence.
That is correct, Chair.
Okay. You then next deal with IPID, commencing from page 43, paragraph 130.
Section 2066 of the Constitution provides that, upon receipt of a complaint lodged by a provincial executive, an independent police complaints body established by national legislation must investigate any alleged misconduct or criminal offence committed by a member of the police in that province. This gives effect to the constitutional in order to give effect to this constitutional requirement, IPID was established under the Independent Police Investigative Directorate Act. As I alluded to earlier, Chair, 2011 Act, not the 2010 Act. Section 2 of the IPID Act mandates the Directorate to ensure independent oversight of SAPS and municipal police services, to conduct independent and impartial investigations into specified criminal offences allegedly committed by their members, and to make disciplinary recommendations arising from its investigations, as well as to ensure accountability and transparency within SAPS and municipal police services in line with the principles of the Constitution. According to the parliamentary media statement of Thursday, 19 June 2025, IPID is facing a severe case backlog of 14,469 cases carried over into the new financial year. This backlog has been flagged as a major impediment to police accountability, as it contributes to a lack of timely consequences for misconduct within SAPS. The delay in finalizing investigations undermined the ability of IPID to enforce disciplinary or legal action against offending officers, thereby weakening oversight and eroding public trust in law enforcement institutions.
Okay.
This statement further stresses that this situation is not merely administrative, but poses a systemic challenge to the criminal justice and oversight framework. Prolonged investigations risk evidence degradation, prolong justice for victims, and create space for impunity within SAPS. Parliament has therefore called for urgent strategies and interventions to resolve a backlog and strengthen IPID's capacity, signalling recognition for that current resources, processes, and case management systems are inadequate to meet its constitutional mandate. In respect of the mandate of IPID, I wish to point out that the Independent Police Investigative Directorate Amendment Act of 2024 amended the mandate of IPID to investigate, specifically the mandate to investigate matters as set out in Section 28 of the Principal Act. Some of the provisions of this Amendment Act came into operation on the 29th of August this year, but the amendment pertaining to Section 28 is still awaiting proclamation by the President and is dependent on the finalization of regulations. The implications of the amended Section 28 are that the mandate of IPID to investigate matters against members of SAPS and municipal police services has been expanded. The mandate will no longer include complaints relating to the discharge of an official firearm or common assault. The mandate will be extended to investigate cases of attempted murder in relation to the discharge of a firearm or the use of any weapon or instrument, and assault with the intention to cause grievous bodily harm, as well as torture, as defined in the Prevention and Combating of Torture of Persons Act. IPID is also in compliance with or as mandated by the Amendment Act, is also authorized to investigate allegations of a commission of an offence where a member, in other words, a member of a police or municipal police service, acted together with other law enforcement officers or members of the public.
Yes, and then you conclude there by saying, or dealing with the impact of the extension of this mandate on the already overloaded work of IPID. If you can then conclude.
The implications of the amendments will place an additional burden on IPID and will require additional resources, including investigators, to execute this mandate effectively.
Then the last topic that you deal with there is the portfolio committee and the identified shortcomings within the oversight structures of police. If you can deal with paragraphs 136 and 137.
The Portfolio Committee has identified shortcomings in relation to the oversight mechanisms within the police. According to a press release dated Wednesday, 12 February 2025, with the title Management Deficiencies from Station Level to National at the Heart of Repeat Audit Findings within SAPS. This Portfolio Committee on Police identified several shortcomings in the SAPS's oversight and management mechanisms. Key issues include repeated audit findings that point to station-level management failures, which persist across regions and are not properly addressed or corrected.
And if I can just perhaps come in, this shortcoming that you've identified here relates to financial issues and aspects of financial accountability.
That is correct, Chair.
You have dealt with the issue of the portfolio committee not acting on or responding to the allegations when they were brought to their attention when Lieutenant General Mkhwanazi was appearing before the Portfolio Committee.
That is correct,
yeah.
Chair.
And then you conclude then by attaching the statement to which you speak in respect of paragraph 137, and that is annexure VR9, which is at 180 to 188 of Van Rooyen 2, correct?
That is correct, Chair.
And you then conclude by saying, should it become necessary, you will prepare and submit a further statement should the Commission so require. And we've indicated earlier, this is apart from the submissions that you are going to make together with SAPS to address this topic, this last topic that you are dealing with, correct?
That is correct, Chair.
Now, you've given your evidence. You received different questions, both from myself and the commissioners. I just want to ask, from your side, is there anything that you wish to perhaps bring across to the knowledge of the Commission, which perhaps you could not, by way of a question that did not present itself?
Chair, there's just one comment I would like to make, and I realize we interrogated this aspect and the difference between policy on the one hand side and direction or directives on the other. And in my opinion, it's neither here or there. What is important is the potential political interference that comes with either the policy or a directive. So it is my submission, if I may guide the Commission, not to focus so much on the issue of whether it's a policy or a direction or a directive, but rather on the legal aspects pertaining to the implications of political interference, and specifically relating to where does the role of a minister stop and where does the role of a national commissioner starts. And in that regard, to bring clarity, as I said earlier, not only for the National Commissioner and the Minister, but even for the organization as a whole, to ensure that there's clarity on the role of each role player and specifically the danger and the risk to address the minimizing of the risk of potential interference. I realize we are talking about specific role players, but the organization will outlive the current role players and there will be new faces. And in that regard, the principles that must be set must be clear for future purposes and to ensure that the organization can withstand potential similar situations in future. As I also indicated, and I think I largely dealt with this matter, is if we consider the issue of oversight bodies, it should be noted that a number of problems that persisted or that originated in the police, albeit the conduct of a deputy national commissioner or even the interference of a minister, were internal issues. And in that regard, if consideration is to be given, I find it difficult to think that oversight bodies, especially external oversight bodies, will be able to address such situations. In a well-disciplined organization, it shouldn't happen. That is as simple as that. And even legislative amendments will not necessarily address the problems experienced in that regard. And therefore, I wish to make the Commission aware of that possibility of just considering my submission in that regard. Thank you, Chair.
So in short, General, I think the point you're putting across is this, and correct me if